Early termination clauses are a crucial aspect of contract law that can significantly impact businesses and individuals. These provisions allow parties to end a contract before its completion under specific circumstances. But what exactly are the legal grounds for early termination, and what consequences might arise? An early termination clause is a contractual provision that outlines conditions under which parties can dissolve an agreement before its intended end date. This clause serves as a safety net, providing flexibility in situations where continuing the contract becomes impractical or impossible. There are several common reasons why parties might seek to terminate a contract early. These include breach of contract, where one party fails to meet their obligations, mutual agreement between both parties, force majeure events like natural disasters or pandemics, financial hardship, regulatory changes that render the contract unfeasible, dissolution of a business, or performance issues where the contract's purpose is not being fulfilled satisfactorily. If you need to terminate a contract legally without breaching it, you have several options. First, you can utilize the termination clause if one exists in your contract. This typically requires providing written notice and possibly paying an early termination fee. Another option is to claim that fulfilling the contract has become impossible due to circumstances beyond your control. You might also argue frustration of purpose if the reason for the contract's existence no longer applies. Identifying a breach by the other party can also justify termination. Lastly, you can attempt to negotiate a mutually agreeable termination with the other party. When a contract is terminated early, the consequences can vary depending on the terms of the agreement and applicable laws. Possible outcomes include payment of liquidated damages, compensation for services already rendered, release from further obligations, or legal disputes that may lead to litigation or alternative dispute resolution. If you're facing a breach of contract, you have several options for handling the situation. You can pursue mitigation by seeking replacement services or goods to lessen the damages caused by the breach. Filing a lawsuit is another option, but be sure to have a copy of the contract and specific evidence of how it was broken. Alternatively, you might consider alternative dispute resolution, which involves a neutral third-party mediator to resolve the dispute without going to court. It's important to note that certain industries have specific considerations for early termination. For example, real estate leases often require a 30 to 60-day notice period and may include termination fees. Employment contracts might have non-compete clauses or severance requirements. Service agreements may have minimum commitment periods, while construction contracts might require proof of non-performance for termination. In conclusion, early termination clauses provide a legal framework for ending contracts prematurely, but they come with potential consequences. Understanding the grounds for early termination, the proper procedures to follow, and the possible outcomes is crucial for anyone entering into or considering terminating a contract. By being well informed about these aspects, you can better protect your interests and navigate contract terminations more effectively.